Trust Funding Checklist. How to properly fund your Illinois trust. Creating a trust is a significant step, but establishing it is only half the battle. Many people overlook the critical step of funding their trusts, jeopardizing the goals they hope to achieve. Illinois estate law and Chicago revocable trust lawyer Mary Liberty provide step-by-step guidance to ensure each asset is properly accounted for. Trust funding means transferring legal ownership of property into your trust's name. You retitle deeds, change account registrations, and update beneficiary designations so that the trust becomes the owner while you remain in control. Under Illinois law, only properly titled assets avoid probate. Anything left in your personal name must go through the Cook County Probate Division. Probate requires a period for creditor claims and court supervision, so funding a trust helps your family avoid costly proceedings and keeps affairs private. Real estate is the first asset to fund. You create a new deed conveying property from your personal name to your name, trustee of trust name, dated, date, and recorded at the Cook County Clerk's Recording Division. Transfers into revocable trusts are typically exempt from transfer taxes, and most lenders permit them without triggering due-on-sale clauses, but confirm with your lender and title company. Financial accounts require in-person retitling. Schedule appointments at your bank or brokerage, bring a trust certification, and ask staff to retitle accounts to your name, trustee of trust name. The process usually takes less than an hour and does not trigger taxable events because ownership remains with you. Banks and brokerages are familiar with the procedure. Retirement accounts should not be retitled into a trust. Federal law grants these accounts tax-favored treatment, and transferring ownership would cause immediate taxation and possible penalties. Instead, update beneficiary designations. Married couples generally name the spouse as the primary beneficiary to preserve rollover rules, with the trust as the contingent beneficiary. Single individuals may name the trust directly. Contact your plan administrator or IRA custodian to make these changes. Life insurance proceeds avoid probate if beneficiaries are named, but naming your trust allows you to control distributions. This is useful for beneficiaries who are minors or have special needs. Request a change of beneficiary form from your insurer and designate the trust. Carriers process these forms within a few weeks, and confirmation should be kept with your trust documents. Vehicles such as cars, boats, and RVs must be retitled through the Illinois Secretary of State. Bring your current title, trust certification, and identification to obtain a new title in the trust's name. Business interests may require amending operating agreements and filing documents with the Secretary of State's Department of Business Services in Chicago. Multi-member businesses must review operating agreements for transfer restrictions and partner consent requirements. Proper transfers ensure continuity if you become incapacitated. Illinois adopted the Fiduciary Access to Digital Assets Act, giving fiduciaries authority to access digital assets. Designate legacy contacts on platforms such as Google and Facebook and maintain a secure list of usernames, passwords, and cryptocurrency access codes. For physical items like jewelry or artwork, Illinois law allows a separate written memorandum under 755 ILCS 5, 4-10, which can be updated without amending your trust. An unfunded trust controls nothing and forces assets through probate. Incorrectly naming your trust on deeds or beneficiary forms can create similar problems. Partial funding, such as transferring your home but leaving bank accounts in your personal name, still forces families through probate. Failing to update funding after acquiring new assets or misnaming the trust on beneficiary forms causes confusion. Trust funding is an ongoing process. Review and update as your life changes and you acquire new assets. Estate planning attorneys in Chicago recommend comprehensive review appointments every 3 to 5 years. Regular reviews ensure new assets receive trust protection and prevent gaps that force families into probate. Illinois estate law helps clients avoid probate by handling deed preparation, coordinating with financial institutions, and ensuring business interests are properly structured. This law firm provides ongoing support to update funding as your life changes. The firm is located at 4422 North Ravenswood Avenue, Suite 212, Chicago, Illinois, 60640, and can be reached at 312-373-0731. Contact them today for a free consultation.